Good afternoon, everyone. Thank you for joining us today for a discussion and update on the FTC final rule on its non-compete ban. My name is Linda Jackson. I co-lead the complex lit group for the firm and co-lead the firm's trade secret, non-competes, and employee mobility group with Matt Pruitt. Our trade secret non-compete group is nationwide, made up of lawyers from a number of practice areas, including litigation, L&E, transactions, and IP. Matt has been our point person on the group's FTC team, tracking its ban and its content and trajectory. Matt is in the litigation group based in Chicago and a true expert in this area. In addition, we have Mike Moltzberger, also in the lit group based in Chicago, Alex Romero in the L&E group based in DC, and Lauren Schaefer also in the L&E group based in Boston. And we are fortunate to have this team of substantive experts and non-compete wonks, if you will. And now I'll turn the mic over to Matt, who will give an overview of where we are and lead the discussion. If you have questions, please use the Q&A function at the bottom of the screen, and we'll address questions at the end. And with that, Matt, over to you.
Thank you, Linda. We'll have some slides that we'll start publishing in just a minute. We will have those on our dedicated webpage that we created to track this issue, along with our various client alerts, some of which have already issued, and then some of which will be following this meeting today. So don't feel obliged to take notes, although I'm sure that you will find this discussion scintillating and very substantive. Because the content will be available on the website, and actually in more detail even than we're able to get into in the hour that we have here this morning. And I do encourage you to please send us questions in the chat. If for some reason we don't get to your question, we can reach out to you directly, and we'd be happy to do so. So if you're logging in on this call, then the likelihood is that you're at least generally aware already of the FTC's the final rule that was voted on 3-2 last week for publication in the Federal Register. And you're probably already aware too that at least 3 lawsuits have already been commenced in order to try to block the rule from actually taking effect. So you may, at the beginning of this call, ask, well, why are we worried about the FTC rule, and why does it matter? Because a lot of observers suggest that it may never take effect, and if it does take effect, it may be only after protracted litigation. So what I will do is just sort of set the stage with the beginning of this, and then my colleagues here will go into greater depth on some of the specific points. But the reason the FTC rule matters is, regardless of whether it ever takes effect or not, the Federal Trade Commission is an august, distinguished agency of the federal government with a long history and a very respected history of managing competition and regulating competition in the United States. What the FTC has published is not just a rule, but also more than 550 pages of commentary on that rule, explaining the FTC's views on the role of non-competes in the U.S. economy. This is a very significant development in the history of non-competes in the United States. And I think that regardless of what ultimately happens in terms of whether this rule is enforced or not enforced, this is going to frame the discussion about non-competes in courts, with employees, in boardrooms for years to come, so that we are all well advised in thinking very carefully about what the FTC has set out here, and using it as a benchmark and a guide and a conceptual framework for how we think about non-competes in the future, because it is very likely that many of the judges and many of the attorneys and many of the executives, frankly, that we may be negotiating with in coming years will be using this document as their own framework for how they approach these issues. So we have up here just the basic takeaways from the non-compete rule that we'll be talking about in more substance over the next hour. First is as you probably know, it prohibits most employers from entering into or enforcing non-compete covenants with most workers. Worker is defined very broadly, and I think Lauren or Alex will be going into more detail on exactly what worker means, but it is very broad. It includes even an unpaid intern. One of the most dramatic features of the new non-compete rule promulgated by the FTC is that it declares prior non-competes unenforceable, which is a retroactive effect. This is distinct from the statutes that have been enacted at the state level, for example, in Minnesota recently, because it actually reaches back and purports to rescind or nullify agreements that are already in place, unless the executive is a senior executive. And Alex will be talking a little bit more about what senior executive means. But senior executive is as it's defined in the agreement, is very narrow, because it requires ultimate decision-making authority at the highest level of corporate governance for the company. Then this is something that will be on the to-do list for many companies. Obviously, if the rule takes effect, is that the FTC will require individualized notice. That's a specific written communication from the company to the employee that the non-compete that the employee previously signed is now unenforceable. And as I said, it applies very broadly, not just to W-2 employees, but to independent contractors, unpaid workers, consultants, et cetera. See if we can get to the next slide. There are a few carve-outs here, and I'll touch on these briefly, and we'll go into some of them in more detail. We probably won't spend much time on our webinar today unless we have specific questions about them, about these carve-outs. Nonprofits, generally, banks and savings and loans, certain common carriers, and franchise agreements. And I guess we have to put a question mark on these exclusions, because if you dig into the commentary that was released by the FTC, and also if you had the chance to look at the transcript or attend live the meeting of the FTC, the open meeting last week where this was voted upon, there were comments by some of the commissioners that suggested that there may be an effort to carve back or push back on some of these exclusions. So there were comments from the commissioners on nonprofits expressing skepticism, especially in the healthcare space, as to whether the nonprofit designation was really appropriate. There was also pretty obviously from the commentary offered by the various commissioners that the exclusion of franchise agreements was not a unanimous view of the commissioners, and that the FTC may be looking more closely at franchise agreements as a basis for future enforcement. Then the banks and savings and loans, the FDIC actually has the power to enforce FTC rules. So it is possible that if this rule takes effect, that it might be enforced indirectly against banks and savings and loans. If we can go to the next slide. The rule includes a few other carve-outs that are actually quite important. One is which you've already mentioned, is the senior executive carve-out. This is the one exception to the retroactive effect of the rule, so that if there's someone who qualifies as a senior executive and they have a non-compete that was entered into prior to the effective date, and keep in mind the rule is not effective yet, so even if the rule ultimately becomes effective, there's still time to enter into a non-compete agreement that would be enforced under the rule with a senior executive. But if you qualify as a senior executive, you can enter into an employment agreement that has a non-compete up until the effective date, and it will still be enforced. Then there is the exception for bona fide change of control transactions or sale of the company transactions. My colleague Mike and I will be talking about those in a little bit more detail in just a few minutes. And then there's the carve out for accrued claims for breach of existing non-competes. And this appears to have been an effort by the FTC to deal with the significant problems of retroactivity. Because if you have an accrued cause of action, there's a very significant takings clause under the U.S. Constitution issue if a regulatory agency purports to take away that accrued cause of action. So if there's been a breach of an existing non-compete prior to the effective date, then that cause of action can still be enforced based on the way the rule is drafted. So that's an overview. Now Lauren from our Boston office is going to take us a little bit more in depth on what is probably front of mind for a lot of us on the call. How do I talk to my employees about the headlines that they're reading in the newspaper? So Lauren, do you want to take it from here?
Thank you, Matt. Yes. So as Matt alluded to, this FTC rule has obviously been in the news. It's been much talked about. Many publications, blogs, people are talking about the final rule. And as a company that relies upon non-compete agreements to protect your legitimate business interests, undoubtedly you are receiving questions from your employees about how the final rule impacts them and their existing obligations. So what we wanted to do for the next few slides was just go through a series of questions that we expect employers are getting from their employees and walk you through some potential talking points or responses that you can have on hand to help navigate those questions. These slides have a sister alert that we have published that goes into slightly more detail. So to the extent you leave this webinar and think I'd really like to reference those talking points, please visit our website and you can find that alert there to help you as you navigate those questions. So the first, probably biggest question that we're seeing is what happens to the existing non-compete agreements that we have in place now that the FTC has banned them, and is the company planning to enforce those restrictions against me? So of course, the FTC rule does not go into effect for 120 days after the date it's published in the Federal Register. It has not yet been published, which is why we're not giving you an exact date as we talk about it during the webinar. But the response here would be to say, first of all, the ban is not yet in effect. We have 120 days after it's published. In addition, we're aware of multiple challenges in court to the FTC's authority to issue the rule, and we're going to get into much more detail later on in the webinar about what format those challenges are taking. But for purposes of responding to this question, you could indicate to an employee the company is monitoring those challenges, and for now, we're not taking any action to rescind or otherwise change our existing agreements with employees. You could indicate that the company intends to continue to enforce the employee non-competes consistent with established law unless and until the courts determine that the final rule is in fact enforceable. And then of course, it's critical to note that even if the FTC's new rule does survive court challenge, existing agreements with most workers will be banned, but existing agreements with senior executives will continue to be enforceable. And then I think a really critical piece of this too is that employee confidentiality agreements, non-solicitation of customers, employee non-solicitation of employees will continue to be enforceable in those states where those types of restrictions are enforceable, even if the FTC rule takes effect. And as a company that's looking to protect its legitimate interests, those restrictions are provisions that the company will continue to enforce. The next question that might be a little bit challenging for employers to respond to, given the fact that the FTC has issued this 500-page description of all the reasons why non-competes are detrimental to workers and to the economy. How do we respond to an employee who asks, I'm reading in the news that non-competes are terrible and harmful to workers and the economy. Why does our company choose to use them? And the response to this generally is going to be focusing on the positive impacts of non-competes. Commentators have stated that non-competes incentivize investments in research and innovation. They encourage collaboration across teams and the sharing of information. They promote worker training and investment of our company into its employees. It increases worker earnings because workers are in a position to negotiate increased compensation in exchange for signing on to these types of provisions. And they also provide certainty to employees who know what the guardrails are as they depart from an employer. So in response to a question like this, we would encourage employers to focus on the fact that our company's success is based upon employees working together, collaborating, creating new innovations and sharing information, and non-competes are one of the tools that we use to help meet those goals. We think it's important that loyal employees who stay with the company are protected from unfair competition, and that we're not in a position where competitors are able to freely benefit from the investment that we make into our workers in form of training and sharing of information, and that type of innovation and the type of investment into employees is something that takes many years to create. And so these non-competes are designed to protect those interests. So that would be the focus of a response to this type of a question from an employee. And the $1 million question, I thought non-competes were already unenforceable. So the response here, the FTC's rule, if it does become effective, is the first ever federal law that would put any limits whatsoever on a non-compete. For more than 100 years, non-competes have been governed entirely by state law. And while there is certainly a movement at the state level to put certain restrictions around the use of non-competes, most commonly in the form of wage thresholds, so stopping the use of non-competes with low wage earners, or notice requirements, so that the concept of people going in with their eyes open, having the ability to know what they're going to be asked to sign before they accept the offer of employment. In light of those guardrails, on the whole, most states are still going to enforce a reasonable non-compete agreement. There are 4 states that are an exception to that rule, but just indicating to employees, the company uses agreements that are currently enforceable under state law, and we comply with all state law requirements. And to the extent that the company is taking steps to make sure that non-competes are targeted to a certain population of employees, highlighting that for employees who would have concerns as well, and just recognizing that before the FTC ban, non-competes very much were enforceable in most states. So I'm going to pass it over back to Matt and Mike to talk about advising the CEO and the board of directors as well.
Yeah, thank you, Lauren. And so Lauren has addressed sort of the front line of non-compete, so to speak, as we think about the possibility that your company's employees may read in the newspapers that somehow the FTC has banned all non-competes in America, and then you look out your window and you see them all at their lunch break, all walking across the street to your competitors. And so the messaging that Lauren was talking about was very important. I do encourage you to read Lauren's very thorough client alert that's on our website that went out, I think, yesterday. Then, so Mike and I are going to take it now to the boardroom level in thinking about the C-suite and M&A transactions and other strategic transactions at the corporate level, and how the FTC's rule will impact those. And Mike's going to start with the discussion first, and then I'll have a few points to follow up. Mike?
Thanks, Matt. So just to set the stage a bit here, I mean, from talking with folks and, reviewing some of the commentary, one might think that, on the one extreme that the sky is falling here because non-competes are gone, and that's going to, change American business life forever and irrevocably and irreversibly. And then, reading other commentary and talking with other folks, you might think, well, there's zero chance that this ban is ever going to go into effect. And so, why are we even wasting time talking about it? And so, and many times in life, when you have these two extreme views, the truth is going to be much, much closer to the middle here. And so, yes, there is a strong likelihood that the rule here is ultimately set aside, but it's still a very important development that impacts both, the way we're going to be dealing with transactions and other issues right now in this moment. And then also, years from now, if the rule does become effective, or even if it doesn't. And so, Lauren, if you could advance to the next slide. So continuing that, I mean, as we all on this call know, employment issues and employment law issues are important issues. They're incredibly important issues. You know, personal capital and investment on our employees is paramount. At the same time, this is not, you know, quote unquote, just an employment law issue. The FTC's rule and the impact of that now and in the future is something that's going to be felt not just for, you know, employees, but also executives and also folks in the boardroom. So the first point here is just that the FTC's attempt to ban non-compete still matters, even if it is blocked by the federal courts. And it matters for a number of reasons. Matt's already talked about some of them, and then in a few minutes here, he'll talk about, you know, some more examples of how it's going to impact, you know, board level transactions. And then Alexander's going to talk about the impact of the rule regardless. But this is a large development that's part of a long-term trend. As others have mentioned, Minnesota recently became the 4th state to ban non-competes, but a number of other states recently and in the past few years have banned non-competes for lower wage workers. And so, you know, this is sort of the next step, the next evolution of that is these outright bans. And so regardless of whether the FTC's rule is actually becomes effective, we are still going to see these similar developments at the state level, and we continue to expect to see more states ban non-competes. And so this is an important inflection point for real discussions about how are we as a company going to continue to protect our legitimate business interests in a world where non-competes may be enforceable, may not be enforceable, and how do we go about doing that? And we have a checklist of sorts at the end of the presentation with some specific action items that we think folks should be considering to look at about how to, you know, what steps to take now to protect yourselves from a world where non-competes may be unenforceable. So I think with that, Matt, I'll turn it back over to you. First, if there's anything else you want to, you know, add on this slide, and then, you know, to walk through some of the specific transactions that we had talked through.
That's great. Thanks, Mike. So, Laura, if we could just go to the next slide. So I wish my boardroom looked quite that cool, but I do. The picture's great. So the FTC's rule as drafted is potentially deceptive because there's a carve out for a bona fide sale of business that says that it will not be, well, the rule will not apply to a non-compete clause that is entered into by a person pursuant to a bona fide sale of a business entity, of the person's ownership in the business entity, or of all or substantially all of the business entity's operating assets. The problem with that carve out, and I think Alex is going to have some further comments on this in just a minute, is that it doesn't really connect with the reality of how transactions are accomplished these days. So just to think about the typical C-suite executive, so we're talking a CEO or CFO or, you know, other senior executive in a company. That executive may receive, at the time that the executive commences employment, a grant of equity that vests has time-based vesting. They may receive the right to participate in a long-term incentive plan that may award options that again vest over time. They may depending on the nature of the transaction, if it's a legacy CEO in a company that's been acquired, they may have rollover equity that they're reinvesting the proceeds of the sale into the surviving or newly formed entity. So, and then on top of that, you're going to have an employment agreement with the executive, and the employment agreement is going to have a non-compete covenant. So it's actually pretty rare for Mike and me and the rest of us in our practice when we're dealing with someone on the C-suite where there's only one non-compete agreement. There actually are 2 or 3 or 4 or 5 non-compete agreements. And sometimes there's an affirmation of that non-compete agreement that happens on an annual basis. every time there's a new award of equity or units or phantom stock or however the structure is created. So when we try to take that structure and compare it with what the FTC has created, it's very challenging because the FTC has, as the way they've drafted this rule, it has buckets that are, they don't really align with how transactions are actually structured. And then on top of that, they've created this concept of a bona fide sale of business, suggesting that they're going to look behind the form of the transaction and try to discern the substance of it and whether it's, really an employment agreement, or I hope you guys saw the air quotes there, or whether it's actually a transaction in connection with the sale of a business. So that creates a great deal of uncertainty in terms of how transactions will be drafted. We've already had a few clients come to us and ask us for assistance because on the sell side, they are getting already pushback from the buyer who's using the FTC's rulemaking as a talking point to chisel on deal value and to ask for a discount. So one of the things that we would encourage our, if you're people listening on the webinar is to think through and to anticipate that pushback. So I think you'll come out of the webinar armed with talking points on how to address those questions when they're raised in the deal making context. But just to run through them briefly, the first is that the FTC rule probably will never be adopted as it's drafted. It will probably be struck down by the courts for reasons that have nothing to do with non-competes and a lot to do with the limits of what a federal agency can do through rulemaking. Then two is that is to focus on the company's other protections. And then I think Alex is going to be talking about this in just a minute, but trade secret protections, confidentiality covenants, non-solicitation of employees, non-solicitation of customers. And if you're going into a deal, you want to have those talking points ready so that you don't get caught by someone who's using this as a talking point to try to reduce value or reduce the price. Similarly, you may end up in a situation when your company is hiring a new executive, when you're onboarding you're recruiting a new CEO, for example, you may get pushback on why the company is tying the compensation package to a non-compete that arguably would not be enforceable, or maybe more than arguably would not be enforceable if this rule actually takes effect. I suppose the first part of the answer to that question is that those severability clauses that we always used to think of as boilerplate, they're not boilerplate anymore. They're actually quite significant potentially. And so when you're drafting the non-compete covenant, you need to pay very close attention and be very thoughtful about the severability clause if in the event that part of the agreement is found to be unenforceable. And you also need to draft the covenants in a way that makes it easy to sever out the non-compete so that you can still preserve your confidentiality covenants and your non-solicitation covenants. That type of battleground is going to potentially become much more significant. The other piece, especially for public companies, that's I don't think has gotten much attention yet from the commentators, but is quite relevant potentially, is what do you do with as I'm sure most of the audience is aware of, the equity packages for senior executives for publicly traded companies often receive a lot of scrutiny because there's the concern that the company may be overly generous to the detriment of its shareholders in giving packages that are too sweet and generate too little value for the shareholders for their senior executives. And this has been an issue for, at least a perceived issue, for decades. So this FTC rule creates, another layer on that level, on that issue, because there is a potential for, if the FTC rule is actually upheld and it's ultimately becomes effective and is enforced, then part of the package that a typical senior executive in a public company is receiving in terms of their various equity rights and grants and options that they're receiving is part of the justification for that is the non-compete. And so when you're entering into the non-compete agreement with a new executive now as part of their executive compensation package, it is worth giving some thought to whether you want to have a specific allocation of compensation that is just for the non-compete covenant. So it is clear to your shareholders that as a public company, that you're being thoughtful about the possibility that the non-compete might be invalidated and trying to align the compensation accordingly. I will say that's not fully considered advice at this point. This issue is new, and I raise it as something to think about in conjunction with your executive compensation and tax and employment lawyers. There's one question that we got in the chat that I want to address now, and then I'll pass the mic to Alex next. But we received a question for non-competes. For non-competes that we're drafting now, should we include an acknowledgement that the employee is a senior executive? That is a very good question. I think that you definitely, for an executive who has the potential to qualify as a senior executive, you want to keep an eye on the FTC rule and the definition of what counts as a senior executive. Alex is going to get into a little bit more detail on that, but job description is going to be very important. And so it's not just what's in the agreement, it's the agreement plus the job description and the description of the executive's authority. And as Alex will probably explain, it's where that person sits in the corporate hierarchy could be quite important in qualifying them as a senior executive. But the question was a very astute one, and I 100% agree that this rule needs to inform how you are drafting the job description and the recitals in the executive employment agreement. So, Alex, do you want to jump in next?
Yeah, absolutely. Thanks, Matt. So, one of the first questions, that I think has sprung to the minds of a lot of people who are potentially impacted by this rule is, what does it mean for me now if I am with an organization that is currently trying to enforce a non-compete against an employee who has just left? What does this mean if, one of my senior executives just walked out the door and I looked on LinkedIn and saw that they've joined my competitor? And of course, as an employee, the question is, what is this rule? How does it impact me if I'm thinking about making a change? So, as Matt alluded to at the start of the webinar, the final rule, and if you could jump to the next slide, does contain an express carve out right now for current litigation where a cause of action related to a non-compete has accrued prior to the effective date. And as a reminder, we have a little bit of a grace period. The rule will not take effect until 120 days after it's published in the Federal Register. So, on its face, the rule would not act as a bar to any existing litigation that, an organization may be a party to where they're seeking to enforce a non-compete. The carve out here, though, is broader than that. It includes any situation where a cause of action has already accrued which we interpret to mean that if the circumstances exist currently on the ground that would allow you to assert some type of a claim to enforce a non-compete, you would still be able to do so, as a result of this carve out. So of course, if you are an employer where you think you have a situation where you may soon need to enforce an existing non-compete, you want to make sure that you have taken the steps that you need to in order to establish that your cause of action has already accrued before the rule takes effect. So if you do have an employee who has just left and you think that they may be going to a competitor, you want to take, all the steps that you can to investigate that situation and make a determination as to whether or not you may need to actually, file some type of litigation in order to enforce that non-compete. You want to make sure that you are taking steps to develop those facts now. And of course, the best evidence of whether or not a cause of action has accrued prior to the effective date is if you've actually gone and filed something to seek enforcement of the non-compete. Next slide, please, Lauren. So then, the next question is, what is the impact of this rule now that it's come out? It's created massive waves. It's obviously a very consequential piece of rulemaking. What is the impact even before the rule takes effect? And, I think it is correct that employers, who may want to enforce a non-compete that could potentially be barred once the rule takes effect, should act promptly to, make sure that, they can make a claim to have that non-compete be grandfathered under the rule. But I think it is also accurate to say that the rule is going to impact existing litigation before it takes effect and whether it ultimately survives, the legal challenges that have been filed against it. Anyone who has enforced a non-compete before is familiar with the concept of reasonableness. A non-compete is only going to be enforceable if it is reasonable in terms of, temporal limitation, geographic scope, but there's also an assessment of whether or not the non-compete is unduly burdensome to the employee who is subject to it. And there's also an assessment of whether or not the non-compete will cause any harm to the public, any harm to public policy. And what the FTC has done with this rule is they have laid out an extensive roadmap of all of the various types of harm that they see as a result of non-competes. And we expect, regardless of the fate of the rule, regardless of whether your litigation is pending before it takes effect, that, this litany of horrors in the accompanying supplementary information could be pretty persuasive to courts that are asked to rule on whether or not a non-compete is reasonable in its scope and in its effect. And we expect that employees and individuals who are defending against claims relating to non-competes are going to rely on it quite heavily. And the rulemaking itself is something like 600 pages. The actual text of the rule is maybe 10 of those pages, and the rest of it is essentially factual findings by the FTC as to what they view the harms from non-competes to be. And they generally tend to fall into two broad categories. One relates to the impact on individuals. There is an extensive discussion of, the extent to which the FTC thinks that non-competes are coercive to individuals. There's also an extensive discussion of the competitive harms that they see arising from non-competes, the impact on business formation, what they call a problem of, inefficient matching between employees and employers. And so we expect that if you are trying to enforce a non-compete, whether the rule is in effect, whether you're arguing that a carve-out should apply, you should expect your opposing party to rely pretty heavily on what the FTC has published. Next slide, please. So as Matt and others have...
Alex, I'm just going to jump in and just say that I see a bunch of questions in the chat from our attendees about this carve-out. So I'm jumping in to say, pay attention, guys, because your question is about to be answered by Alex. So take it. You can take it from here.
Absolutely. So the rule, it's very clear that the FTC wants the ban on non-competes to be construed quite broadly. It's also clear that they want the carve-outs to be construed quite narrowly. But the way that a number of those carve-outs are drafted leaves open a ton of ambiguity as to what their actual scope is and what it's going to look like in practice. And we expect that, if the rule takes effect, that these carve-outs are going to be subjects of extensive litigation, which is going to be necessary to figure out what they actually cover. The biggest one, unsurprisingly, and certainly unsurprisingly in light of all of your questions, is what is a senior executive? And here, we can point you to the text of the rule, and it includes an express definition for a senior executive. But we've gotten a number of questions on this topic from clients already, and one of them said, well, the definition is clear as mud, and we would agree with that. So there is, first of all, a salary threshold. The individual has to make above about $151,000 on an annualized basis, but they also have to hold what's called a policy-making position. And it's not sufficient for them to hold a position that allows them to heavily influence policy decisions that are made by the organization. They have to have a role where they have the final authority to make policy decisions that control significant aspects of a business entity or common enterprise. What does that actually mean? We're not sure. It could mean that a senior executive is someone who is, the head of or the ultimate authority within a significant aspect of the business. We've gotten a lot of questions about, is my director of sales a senior executive within the rule? We think an argument certainly could be made, but it still is going to come down to what this phrase final authority actually means. Does it mean someone who is the final decision maker with respect to issues of significance within the business? There's an argument that could be made that way as well, but we're definitely going to need, additional litigation to hammer out the specific parameters of this exclusion. Next slide.
Just one really brief point on that, Alexandra. So
yeah.
Interesting, just furthering the ambiguity point, but I mean, according to the FTC's, the adopting release, they estimate that 0.7%, so less than 1% of employees they estimate would actually meet the definition of what they think of as a senior executive. And to me, that just shows a fundamental mismatch between what's written here, because I would think that more than 0.7% of employees probably have final decision-making authority and make more than 151,000. So to Alex's point, this is an issue that's going to have to get litigated, but at least the FTC's adopting release suggests that it takes a very narrow view of what percentage of folks will actually meet this definition.
Absolutely. Thanks, Mike. So the next kind of big ambiguity we see goes to the heart of the rule. What is a non-compete that is covered by this rule, that is going to be prohibited by this rule once it takes effect? Seems clear, obviously, that express non-competes that prevent an employee from going and working for a competitor would be covered. But the way the definition of non-compete is drafted in the rule suggests that it could actually be significantly broader than that, which is confusing to an extent because, one of the significant justifications that the FTC uses for why this rule is so important is they say non-competes are not necessary because employers have all of these other tools at their disposal to protect their legitimate business interests, to protect their confidential information and trade secrets. And so that's why non-competes are not necessary. But the rule defines a non-compete as any type of covenant that would function to prevent a worker from working or operating a business after the conclusion of employment. And so you can imagine a variety of different scenarios where that definition could be quite broad. There could be a situation, for example, where a non-solicitation provision, depending on the industry, depending, on the nature of the work that the individual is doing, could function in some ways to prevent that person from, working in the industry that they have been working in. You can envision this happening in the sales context in a variety of different ways. It certainly calls into question forfeiture for competition clauses, which are very common in, executive incentive comp, plans or deferred comp plans, which say that the individual isn't necessarily barred from competing, but if they do choose to go work for a competitor or engage in competitive employment, they have to forfeit the compensation that they've received up until that point. So does that constitute a non-compete? We suspect that the FTC would take the view that it does. And so, one of the things that we're going to be talking at the end about, important next steps for employers to take, but one of those is going to include, making sure you're taking a look at the other tools in your toolbox, and making sure that they are not themselves vulnerable to attack because they're so broad that they could actually function in the way that the FTC envisions a non-compete working. Next slide. All right, so there are a couple additional carve-outs that I'm just going to touch on, quickly because we want to make sure we leave, time for a few questions. But as Matt talked about at the beginning, there are some kind of jurisdictional carve-outs that are included in the rule. Nonprofits is a big one. The FTC does not, have jurisdiction over nonprofits. That being said, if you attended the public meeting that the FTC held rolling out their rule, you probably noticed one of the commissioners, I believe it was Commissioner Slaughter, talk about how nonprofits might fall within the jurisdiction of the FTC and the rule if they operate like a for-profit entity. What does that mean? We're not quite sure, but it does suggest that there would be some additional analysis done beyond just looking at, the status on your tax forms. And then similarly, as Matt talked about at the beginning, banks, saving and loan institutions, common carriers, it's indicated that they would be carved out from the rule. He already talked about the bona fide sale of a business. And the FTC also talked about excluding non-competes that are contained in franchise agreements, but it became pretty clear through the end of the meeting that there was, some divergence of opinion on that and suggests that franchise agreements could be an area of future enforcement. Next slide.
Before we,
Thanks. Thanks.
Can we go back
Mike,
once?
go ahead.
Sorry, Alex, can we go back one slide? I just want to emphasize, so we had some questions about the sale of the business. So I think Matt mentioned this already, but just to emphasize, the rule does contain an exception for non-competes entered into as part of a bona fide sale of a business. But the bona fide sale of a business, that term bona fide is undefined in the rule. The commentary suggests that it has to be a third-party transaction at arm's length between a buyer and seller. And so that sort of like sale of a business carve out, it's not apparent at all, like Alex mentioned, that that's going to somehow permit like equity grants to contain non-competes and that those would be enforceable. So we had a number of questions in the chat about equity grants. And just to be clear, the FTC's rule as written appears to be broad enough to likely capture and ban many equity grants that would be included in those types of, would ban non-competes that are included in many types of equity grants. But that's like, that hasn't been litigated. We don't know that for certain, but that's the way that the rule reads. And of course, there's a lot of variation, going to the ambiguity point, about what an equity grant is and different forms of deferred compensation. But that's what we say when we say this isn't just, an employment law issue. This rule would be broad enough to ban non-competes in all sorts of different places, not just, in a strictly speaking, an employment agreement.
So Mike, I want to pick up on that just a little bit further, because this seems to be one of the main questions that we're getting from our audience who've logged in here. Lauren, do you mind, can you take us back to slide 13? And we'll do this quickly because we only have about 10 minutes left, but I do want to just look at this language, because we've gotten almost all of our questions in the chat have been about incentive plans and stock plans. So what's really interesting about this is this is the actual text of the rule from the FTC. Non-compete covenants entered into by a person pursuant to a bona fide sale, and notice these 1, 2, and 3 are disjunctive. So there are 3 alternative scenarios as this is drafted. 1, sale of a business entity. 3, I'm skipping ahead for a reason, of all or substantially all of a business entity's operating assets. So I think we know what those 1 and 3 mean. It's a stock sale or an asset sale, seems to be what they're trying to get at. And number 2 is really interesting because it's disjunctive. Of the person's ownership interest in a business entity. So if you were to read this in isolation, it would look like the FTC was trying to carve out a scenario where, and hardly unusual, where an executive has a plan that provides for the executives units, phantom stock, actual equity, whatever, to be bought back when the executive leaves the company. And that would seem to fall within the scope of the person's ownership interest in a business entity. But I want to caution that when you read the supplementary publication, the commentary that goes with the rule, it's the FTC, what they actually say about this makes it much, much narrower than what it appears to state on its face. So for us, as we've been thinking about this and advising our clients in the first week after this has come out, this is really a key issue does the company and we and then again, to tie it back to Mike's point of the point, I used to think it was the 0.5 of 1%. Wasn't that what the people were protesting about out on the sidewalks years ago? But the 0.7% or whatever it is it's a very small sliver of people that, according to the FTC, are senior executives, and according to the commentary the FTC has published, it is a narrow range of transactions that they anticipate can be tied to non-competes. So that from our perspective, as we think about what is most impactful for our clients, especially in the private equity space, this is quite significant, because it really changes the way that that the typical term sheet and the typical presentation I'm thinking about the PowerPoint presentation that the executives get at the company that when it's about to be acquired by a PE investor. They get all the presentation about how they're going to make lots of money as the company grows and their equity pays out. All of that is tied to non-competes. It always has been. And the idea that that's going to be taken away here is pretty significant. And I think it's one of if there's something that warrants you talking to your outside counsel as you think through the consequences of this, I think that's on the very short list. So I'll get off my soapbox, because if I talk any longer.
Great points by both Matt and Mike and Alex as well. And I think, candidly, just to hover on this for a second, because we are about out of time and we want to skip to our next slide, so we at least touch on some other points that we think you ought to know about. One way to think about that concept, and it is odd that the rule didn't speak to equity programs separately outside of the sale of asset issue. And one thing to think about is the extent to which, to Matt's point, in your deal docs, I think a key distinction is going to be whether that equity program is, quote, compensation-like, because that really seems to be the focus of the rule. So lots to think about, and a lot of devil in the details. I think that's the takeaway with the sales exec non-competes, as well as these equity issues, is the extent to which you can make clear and have clarity in your agreements as to whether it is compensation-like or not, and what an individual's role is. Great points, and I agree is going to be a huge focus going down the road. But let's see what we can get through in the next few minutes, and maybe we have a second session on this. There is a lot to cover.
So, Linda, I think we've actually answered all the questions that are in the chat. So I think we can spend the last few minutes here with this piece, and then the wrap up from you and from me. So maybe if we can do 3 minutes on the litigation summary, and then you and I can wrap up.
Yeah, completely agree.
Okay, so I will speed through this then, but still hit the highlights. So as we've touched on already throughout the webinar, there are currently litigation challenges pending, arguing that the FTC in large part does not have authority to issue the final rule. So I'm just going to highlight 3 of the cases that are currently pending. The first, Ryan LLC versus FTC. This was the first to be filed. It was filed on April 23rd in the Northern District of Texas. This case, Ryan LLC, is a global tax services firm The makeup of the firm is that it's operated by 200 or more principals who are tax experts. And one kind of novel argument that I wanted to highlight from the Ryan case is that they argue that one of the impacts of having their non-competes banned is that they would be forced to shrink the size of client teams, of the size of the teams that are servicing their clients in an attempt to contain the harm, is the quote that they used, which I thought was an interesting argument and not one that we've seen necessarily laid out quite that way in other cases. The next is the Chamber of Commerce case. This is the case that everybody is tracking. It was filed on April 24th in the Eastern District of Texas. And we will, on the next slide, walk you through kind of the dates that are upcoming in that case and when we expect to see a decision coming out of it. And then finally, the ATS Tree Services case in the Eastern District of Pennsylvania. This is an interesting one. It's being brought by a tree service company with 12 total employees. And the bulk of their arguments in that case are that they spend a significant amount of time, energy, resources investing in training in their employees, and that this training, they would not be able to give the same opportunities for training, invest in their employees in the same way if they had to do away with non-competes. So kind of an interesting swath of plaintiffs in these cases. You know, we see very big companies, we see very small companies, and it just kind of underscores the fact that this rule has very broad reaching effect and would truly, you know, geographically, industry, size, it would impact essentially every employer who is relying on these types of agreements.
Why don't we jump that? Thank you, Lauren. That's a great overview. Why don't we jump ahead to slide 25 and just sort of go ahead and do the recap on what Linda, do you have some comments on what employers should be doing now?
Yeah, so in the last couple of minutes, I think, as Mike said earlier, I think the conventional wisdom is that it's unlikely that this final rule will either go live at all after it goes through the injunction process, particularly one in Texas, or it may go live in some other form. But that being said, look, the FTC information on this and all the evidence and arguments that have been lodged in favor of continuing the trend at a national level, what has already begun at the state level in terms of narrowing non-competes, the issue won't go away entirely. And so our recommendation remains that this is really that moment in time to make sure that you are taking full advantage of what the FTC says we should be using instead of non-competes, but they are the other sort of belts and suspenders to what you do to protect your information, right? It's the NDAs, it's the non-solicits, but that they're tailored, they're not overreaching. It's the trade secret protection programs, right? It can be hard to establish trade secret, and part of that is that, as you all likely know, you have to show that you've been treating it as a trade secret status, right? NDAs are a part of that, whether they're individual or corporate-wide policies, right? Limiting access to folks for whom it's necessary, and using other incentives for folks to stay. So this really is the moment in time to go ahead and batten down those hatches, candidly. If not because of the FTC ban potentially going into effect, but even if it doesn't, you're still going to have challenges to your non-competes in litigation. And so you want to make sure that you've got those strong pillars to support your defense of your information and, improper competition. And on these senior executives, there's an opportunity here in this 120-day window that we highly recommend you take full advantage of. Examine your existing agreements with those who fall into that definition. Roll out agreements with those who fall within where you don't have them yet already. Be very mindful of that policy component. Don't make things up, right? Because I think one thing the FTC is saying out loud is everywhere, even in terms of where it has jurisdiction, it would go by a fact and circumstance analysis, right? So you have to have the real life facts to back up what you're putting in the agreement language or the job description. But where you can, make it clear in this next 120 days, lock down those senior executives to the extent that you can. And Matt, pitch it back over to you.
Thanks. We've received permission from our webmaster that we can go for another 5 minutes. So,
All right, webmaster, all right.
it's the world we live in. So I agree with Linda and just really can't emphasize enough that my guess, my expectation is that most of the people on this webinar are people who advise executives and board members and chief human relations officers. And I think this is in one level, it's a gift that the FTC has given all of us as advisors, because we do need to, it's a great opportunity for us to focus our clients and our stakeholders' attention on how the non-compete agreements fit into the broader framework of risk management for the enterprise, and to have a holistic discussion about all of those pieces for the risk management, just as Linda was saying. So never waste a crisis is the short version of what I'm trying to say to you, is that this really is a golden opportunity for every enterprise to be thoughtful about risk management, from insider threat risk and theft of trade secrets and breach of loyalty, which is at least generally captures what companies are trying to manage with the non-compete agreement. So that is at a high level. Please do take advantage of this opportunity for the company to give you as the advisor to the company, either inside or outside, the opportunity to have the time and to engage in discussion on these issues, because they are quite important. We don't know what's going to happen in the future. Nobody does. Some of it, may of course depend on the outcome of the presidential election that's coming up, congressional races that are, they're obviously on the horizon as well. And what we do know is that there is a long-term trend that is increasingly hostile to broad non-compete agreements. And so the company's reliance on non-compete covenants as their first and only line of defense is becoming higher and higher risk. And we don't see that changing regardless of what happens with the FTC's rule. Just in closing, we will remind you that the FTC's, I'm just looking at our slide here, it's not on the screen, but just to recap a couple of things. One is that we do need to keep in mind that if this rule ever goes into effect, that will trigger a deadline to or when it's formally published, you will need to give notice to your employees in writing that their non-competes are no longer enforceable. And then you'll need to think about, of course, the impact, as we've discussed at some length, on current and future transactions. I'm just going to take a look at the Q&A here, Linda, and see if there's anything. I think we've answered most of the, in some form, the questions that have come through. So unless anybody has anything else, we landed at 12:05, which I guess is, I say we got 5 more minutes, so that's pretty good for a trial lawyer.
The webmaster is precise, and candidly, there's a lot to digest here. If we didn't answer a specific part of a question you had, just reach out to any one of us. We're happy to oblige, and we will track the date that the rule is published, and so we'll push out another alert that gives you a heads up as to when that 120-day count begins. So thank you for joining us. It's a lot to process, and delighted to help keep you informed. So thanks very much, and thanks, team. All right.
Thank you, everyone.
Bye-bye.
Bye-bye.